I'm Scott Loughlin. This is the Data Chronicles, and here are your data points. Today, we are discussing the United States Department of Justice latest Notice of Proposed Rulemaking, or what we'll call the NPRM, which seeks to regulate cross-border data transfers, specifically the export of U.S. data to specific countries with tense and adversarial relationships with the United States government. The NPRM proposes restricting and at times prohibiting transactions that involve access to U.S. government and sensitive personal data. In doing so, the proposed rule would mark a seismic shift in how data transactions involving foreign entities will be regulated here in the United States. It's unlike anything that we have seen in the US before. And it's right around the corner. The rule is expected to be finalized as soon as January 2025. We're recording this episode middle of December 2024, and so roughly around a month away. This episode really kicks off a three-part series, which we're focusing on with three parts given the importance of the rule. We'll want to introduce the rule itself, break down its potential impact on trade, exports, global economies, corporate compliance, and then, importantly, the unique application that it will have on the health and life sciences sector. You'll want to tune in to all three of these episodes because the rule really promises to reshape how businesses process and exchange data in a global economy. But before we dive into the rule and what it means for businesses, I want to start these episodes with kind of a tutorial. It's complicated, so you'll need to be patient with me as I introduce the proposed rule and walk through what the proposed rule is, who it's designed to cover, and what it requires from those who are impacted. I don't typically try to do that at the start of these episodes, but this one is so complicated that it requires a moment of discussion. And for those who are patient enough to listen to this overview, I promise we'll get into the discussion really quickly. So let's start at the beginning. The DOJ's proposed rule implements the Biden administration's executive order from March 2024, which we discussed on an earlier episode of this podcast. The rule would regulate transactions that involve three key terms: access by a country of concern or covered people. Second, that access involves covered data. And it's done through a third key term, and that's through a covered transaction. So pause for a moment. We have to have the access by a country of concern or a person who is subject to those laws. It has to be a specific type of data, and it has to be through a specific type of transaction. And in some ways, you may say that all three of those are rather narrow. And you probably will be surprised, or maybe not, if you follow the way that regulation in the space is moving, is that all three of these concepts are incredibly broad and sweeping. So let's break them down. First, we're talking about countries of concern, right? Those covered persons to whom, where can the data potentially be restricted or prohibited? The proposed rule restricts access to covered data by 6 countries of concern: China, Cuba, Iran, North Korea, Russia, and Venezuela. It also restricts access by covered persons. And those are people who are subject to the country's control or law. It doesn't have to be natural people. It can be entities who are tied to the country of concern by a majority ownership, a place of business, or a residence. It also includes individuals who are residing in those countries. And the Attorney General is empowered to designate additional covered persons who could also include U.S. entities, individuals, or frankly, entities or individuals around the world. The DOJ here is specifically concerned with access to US government related data. That's probably the narrow set. And then what they call bulk US sensitive data. The government related data is pretty specific. It includes information about government personnel, sensitive locations that could be exploited for national security risks. That is going to impact some organizations in very specific and robust ways, but a lot of organizations don't necessarily have robust information about government personnel or sensitive locations of government facilities that could create those kind of risks. And so the much broader application is that second component, the sensitive personal data. That is defined much more broadly and includes health, genomic, biometric, geolocation, and financial data. But importantly, it doesn't stop there. It also includes specific combinations of more common personal identifiers, things like demographic identifiers, names, for example, login credentials, device IDs, and call records. So it can end up being applicable to data that many large organization has in its databases. And then you may say, okay, well, it relates only to bulk transfers of sensitive data. And that's true, except that the definition of bulk is not a traditional layman's definition of bulk. Depending on the type of data, the definition of bulk varies. It goes from as small as 100 people in the case of genomic data to 100,000 people in the case of other types of personal identifiers. In other words, thresholds that are easily met by large organizations operating global businesses. So finally, the proposed rule targets specific types of transactions. It breaks those transactions down into two. One's that transactions that are flat prohibited. You can't do them. And those are data brokerage transactions, kind of the buying and the selling of data, that involve access to those covered data elements, and then transactions that involve bulk access to genomic data or biospecimens. That's going to be the category that are flat out prohibited. We have the second category, which is probably going to be many more, and it'll probably be generally much more broadly applicable because it relates to any transaction which could include things like vendor agreements, employment agreements, and specific types of investment agreements that could have access to covered data. Vendor agreements, employment agreements, investment agreements, these are the kind of agreements that are happening day in, day out with not necessarily the same type of scrutiny or the same type of focus that other larger transactions would have. So the prohibited transactions, unless there's a specific exemption, the US entities are just going to be prohibited from engaging in those transactions and will need to restructure those commercial relationships. The second category, those that are restricted, are going to be allowed if and only if the US entity can implement a robust compliance framework that requires things like due diligence, audit, record keeping, and then specific types of security measures that would prevent the country of concern from gaining access to the data. Really, really high standard. This is going to inevitably include new contractual requirements, data minimization strategies, privacy enhancing technologies, audits. It's going to be a whole host of things that organizations may do in some ways and will now need to do much more broadly. The proposed rule would also exempt a number of transactions, including transactions for the provision of financial services, including routine industry operations with subsidiaries and necessary regulatory approvals. So there's a whole host of exceptions, right? We have the broad rules that apply generally, and then we have all of these specific exceptions. So with that, I recognize that was a lot that I just threw at you, and I'm hopeful that as you start to make sense of it, that will kind of create the basis for our much more significant conversation, where it's where we'll go next. As you start to learn all of this, And as you start to wrap your mind around what the significance of this set of rules would be, one important thing will jump out. If you have any exposure to one of these countries, whether it's through ownership structures, employment relationships, vendor engagements, or otherwise, you'll have potential issues under this proposed rule. For US organizations, my guess is the concern is largely going to focus on connections to China, which are common given the robust ties between the two economies. So it's a big deal, and it will, frankly, interrupt business as usual. In particular, the proposed rule is going to prompt a number of new and important questions, some of which have really difficult answers. What types of data transactions are we engaged in? What type of data are we giving third parties access to? Where are those third parties located and organized, and who are they owned by? These are difficult and frankly may not have been asked or scrutinized in the past. And so when I said it's a seismic shift, I honestly believe that this is a sea change in the way that the US organizes and approaches global data transfers. All right, that's the overview. Now let's jump right into the discussion. And to do that, I've invited my colleague, Ajay Kuntamukkala, to talk through the scope of the rules and the regulated transactions and the global commercial implications in greater detail. For those who don't know Ajay, Ajay is my partner, co-lead of our international trade practice and head of the DC office. And there's frankly nobody who knows global commerce better than Ajay. Ajay, welcome to the podcast.
Thanks, Scott. How you doing today?
Doing all right. I'm excited to go through, I think what is probably a significant development that's going to, probably impact both of our practices. As I mentioned in our introduction, you co-lead the trade practice. I co-lead the privacy practice. And here we have a rule that is part trade, part privacy, part sanctions, part cyber. It basically covers the gamut.
Yeah, and Scott, we've always worked together, but I have a feeling that going forward, we're going to be working a lot together on this particular rule.
Yeah, 100%. So maybe let's just start from your perspective. What are you thinking that the big key elements are of this proposed rule, and what do you find to be the most significant for our clients?
Yeah, so let me start with a little bit of context about this rule, because we have seen, frankly, a flurry of new rules coming from the Biden administration as it winds down and the transition to the new administration begins. This is one of several national security focused rules that we have seen. And what's interesting about this rule is it's a new national security program. And it's a new national security program that sits within the Department of Justice, which is a little bit unusual because typically we see these national security programs at other agencies like the Commerce Department or Homeland Security or at OFAC in the Treasury Department. But the administration made the decision to put this particular rule within the Department of Justice. And this is really because the Department of Justice does have a role in counterintelligence. And they view the issues that this rule is addressing, which is access to certain sensitive data here in the United States by countries of concern. And these countries include the usual suspects, right? China, Russia, Venezuela, and so forth. And so really the point of this rule here is to implement both prohibitions as well as restrictions on certain types of transactions related to bulk data and government data. And we'll get into the details of it. But I did want to, again, emphasize that the Justice Department really has to stand up a new organization to deal with these rules. In fact, they're hiring. So if anyone's looking for a job out there, there may be opportunities at the Justice Department to help implement a new program. And it's giving the Justice Department new authorities, because typically when you think of the Justice Department, you think of criminal prosecution. Here, they're putting a regulatory function that involves, licensing and issuing advisory opinions, handling civil enforcement in addition to criminal prosecutions. So it's putting these new national security related authorities inside the Justice Department. And that's really interesting, and we'll see how that develops.
Yeah, I mean, Ajay, that's a really kind of key component of this, especially with now that the DOJ playing this part, law enforcement, prosecuting role together with this regulatory role. And also, it's important to note that we actually had legislative action in this space over the summer when Congress passed the aid package to Israel and to Ukraine. There was also provisions in that statute that would have prevented or has prevented organizations in the United States from selling data to organizations that are connected to countries of concern. And it is very much, focused on a portion of what this rule is designed, where this data brokerage concept. And the authority for enforcing that law lies not with the DOJ, but with the FTC. And so now we have another set of rules, perhaps much more comprehensive, that are going to be enforced by a DOJ who has not, at least historically, been a regulator in the same way that the FTC is. And we have a portion of the same content being regulated by a traditional regulator in the FTC. Seems like it is really set up for lots of clarity around who you're going to be working with going forward on this issue.
Right. And certainly the lack of clarity right here between what agency is doing what, and perhaps there'll be clarity in the future as they settle into their rules and roles around these proposed rules. But certainly we won't be hurting for work, Scott, given the overlapping jurisdictions here. Now, the other interesting thing about these rules is they're really a mashup of different concepts that you see in other regimes. So not only do you have the data privacy elements that you and your team deals with on a daily basis, but you have concepts here that are imported from the Commerce Department, from OFAC. So there's sanctions and export controls concepts in here, really around the licensing and advisory opinion, and around the enforcement aspect of this. And then you also have the mitigation, the transactions aspect that comes from the CFIUS program. So they've borrowed from different national security programs, and you kind of have this mashup of different programs here.
Right. But then, the purpose of it, I think, is squarely around national security. So while, the regulated transactions or the covered transactions are very focused on the relationships between various parties and personal data moving from point A to point B, which could be connected to a country of concern, it is not really a privacy law. It's not designed to protect the rights of individuals and to protect their personal freedoms, or to protect how, give them the ability of managing who knows what about them, in the same way that we've seen similar statutes, similar regulations primarily come out of the EU and some other jurisdictions that do broadly regulate cross-border data transfers. Here, we're trying to get after or trying to regulate those data transfers, perhaps in some of the similar ways, but for the purpose of national security and not for the purpose of trying to protect individuals and consumers. Interested in that, right? Because that's a significant sea change in a way to think about all of the legal issues that come together with the processing of personal data.
Yeah. And that's why if you're coming at this purely from a data privacy perspective, or you're a data privacy practitioner, you may look at this and just scratch your head. This just seems unusual in terms of how data is being regulated here. But it's to a trade practitioner or a national security practitioner, it's not at all unusual the way they're going about this. And the complexity of it is pretty consistent with how they've approached other national security issues. It's important to note that the set of regulations is pursuant to an executive order that was issued by President Biden last year. And that executive order is based on IEPA, the International Emergency Economic Powers Act, which is the statutory basis for a lot of the national security regulation, including sanctions and export controls. It's that same statute they're using as the authority for this regulation. So that's why some of these concepts are similar. But perhaps we should, go into some detail about the nature of the transactions. And this is really like a 2-for-1 special, right? Because there's really two programs in one here. One is the restriction, the prohibitions, as it were, around what they're calling prohibitions, around data brokerage transactions, where those transactions provide access by particular foreign adversary countries or countries of concern to certain types of data. And that includes personal data, right? And as well as government-related data. And they've defined those in a particular way. Perhaps, Scott, you can get into some detail around how they've defined that. But the other part of this program, and that part of the program really does relate to these countries of concern, very much seems like national security restriction. The other part of this program is what they're calling restrictions. And under the restrictions, particular types of agreements, whether it's an employment agreement or other type of, investment agreement or other types of agreements, these agreements, if you have these agreements and those agreements provide for access by any foreign person to certain types of data, then that is going to require the company to implement just a series of compliance measures, including due diligence and auditing and other types of compliance measures, record-keeping requirements. And that is broader. That's not just to the countries of concern like China or Russia, Venezuela, or North Korea, Iran. We're talking about any country. This could be a European country, or it could be Canada in theory, right? So if these agreements provide for any access by any foreign country or covered persons from those foreign countries, then you're going to have to implement these compliance measures, which look more like the data privacy or data security measures that we've seen. But perhaps you could get into a little bit more detail around those two elements.
It's really the right way of thinking about it, is the 2-for-1 as you described it. I mean, that data brokerage concept and the sale of data, that is going to be within the crosshairs for what would be prohibited, right? Essentially, just can't do it anymore. And I think many organizations may see that and they say, oh, okay, well, I don't really sell data to China. I don't sell data to Cuba. I don't sell data to North Korea. This is not really something that impacts me. And in some ways, that's true, except I think maybe those who spend a lot of time in this space realize that the definition of sale, what constitutes a data brokerage, what constitutes bulk, all of those have probably non-traditional meanings to people who are like, oh, I don't sell data. For those who are involved in trying to interpret the CCPA and the state law obligations associated with data-related transfers, oftentimes they say, oh, I don't sell data, but the definition of sale is much broader. And I think the same is true for what would constitute a data brokerage relationship. Data broker in this concept is any entity that sells personal information for whom the entity did not have a direct relationship. And so, in other words, if you collected information about a person, but you didn't have a relationship with that person, and then you go on to transfer that information or quote unquote sell that information to a third party, that is going to constitute a data brokerage relationship. And that is what is now prohibited when you do things, with that definition of bulk. The definition of bulk will depend on the type of data that we're talking about. And it can range all the way from a small number, for genomic data, precise geolocation data could be anywhere from 100 to 1,000, all the way up to a much larger set of data for a larger expansive data set, and that could be over 100,000 people. So it ends up being that it's not an easy law to decipher based on traditional layman definitions of how we would see these terms in action. But instead, it gets very precise about exactly how you collected this data, from whom you collected this data, what was the relationship that you had with the third party with whom you're transferring this information, where is that third party based, who owns that third party, like a very fact specific set of questions for you to even get to the position of determining what is prohibited. And frankly, that's a difficult item because these types of transactions are happening all around us. And in addition to that, it's often not the case that you fully understand all of the data that would potentially be involved in those transactions. And you certainly don't know what the ownership structure is of the party that you may be interacting with, what their connections are to a country of concern. So it really puts the US entity in a position of having to know a lot more about almost every single one of their relationships that involve any type of transfer of information. And that's only on the prohibited side. And the restricted side, it's the same way because you have to look at, well, every time I have an investment relationship, anytime I have a relationship with a vendor, anytime I have a relationship with an employee, all of those are relationships that are now within scope of the transaction. And depending on how much data is being passed, depending on the level of access that relationship will create, and depending on where those entities are based or where they're connected, there will be new obligations. And this is I think, a really important moment in the way that we see global commerce, because it's not saying many times that commerce is prohibited, right? It's not saying you can't do these things, but sure, you can't do it without a lot more information than perhaps organizations are accustomed to acquiring today. Interested in your thoughts on whether you would see it differently.
Yeah, no, I think all of that makes sense. And so compliance programs, due diligence, well, number one, having an understanding of your own data, and mapping those data flows, I think is going to be extremely important when it comes down to complying with these rules. And then just having a very robust compliance program. And it's interesting, they actually say in the rule that the compliance program can be risk-based, and they reference OFAC's compliance guidelines. So the sanctions compliance guidelines, they're referencing that, for purposes of a compliance program for these rules. So they're again borrowing concepts from these other national security programs, but it's going to require a lot of legwork to the extent the company is considered a data broker or is engaged in these other activities set forth here. It's going to require a lot from them. A couple other interesting parts of this is, especially for the life sciences industry, right? They've defined one of the categories of sensitive personal data includes human genomic data. In addition, it's not just data. This rule actually regulates the provision or the export of biospecimens to a country of concern. So this could impact, for instance, life sciences companies that are engaged in clinical trials in China, right? And they need to send biospecimens. They need to send human genomic data, because that has to be evaluated by a contract research organization in China, or they're sending biospecimen data. All of that could be impacted. Now, the rule does include certain exceptions, and there are certain exceptions. They look somewhat narrow, related to, and there's a whole range of exceptions related to public information and so forth. And there's also exceptions for some research and development activities and clinical trial activity. So it's possible some of that activity, depending on what a company is doing, could be exempted from the rules. But again, one has to look very carefully at these rules.
Yeah, and I appreciate your flagging that. We'll have a complete other episode for our listeners that are focused on the healthcare and life sciences space in particular, because one of the things that's important to know about this is that the rule is industry agnostic, right? Unlike many of our other regulations or laws in the United States that focus on a specific industry, this one applies to every essentially US person. But even though it's applicable across the board, it won't have the same impact across the board. There are specific industries, healthcare, life sciences in particular, are going to be uniquely impacted probably my guess is the second group is going to be the finance sector, which is used to sending data globally in order to allow for global commerce, and that may have gotten a whole lot more difficult. And we'll have a guest, our partner Liz Boyson, to be able to speak to some of those elements as well.
Yeah, yeah. Thanks for flagging that, Scott. Now, if you may listen to all this as a company and think, how in the world am I going to deal with this? And especially if you think you're going to get caught by the prohibitions, that's going to, if that activity is core to your business, and does this mean I'm going to have to shut down my business? And I would say, no, not necessarily, right? Because there is provisions in this rule that permit for licensing. And there's two types of licensing. One is general licenses and the other specific licenses. And so the agency here, DOJ, would have the ability to issue a general license that permits certain categories of activities without a company having to come in individually and seeking authorization for their activities. So these general authorizations or licenses would be issued and published. And if you meet the terms of those general licenses, then you can proceed with those activities. There will be record keeping and reporting obligations likely associated with those general licenses when they issue them. We don't know what those are going to be. I think they'll probably have to study what classes of transactions they would generally authorize. And so that is one part of this. The other part of it is if you don't have a general license, if you're not carved out by an exception, and they don't issue a general license that covers your activity or your type of activity, there is the opportunity to go in as a company and ask, or as an organization, to ask for a company or organization specific license that's issued to you for your particular types of transactions, or specific types of transactions, specific counterparties, specific countries that are involved. So it is possible to get authorizations to do what you need to do. Now, we don't have a sense of what the licensing policy is, like what are the kinds of things they're willing to license. Presumably North Korea and Iran are going to be out of the picture, right? But given and Russia, right? Those are countries I wouldn't bet on in terms of getting expansive authorizations to do business. Now, China, on the other hand, is very different. China is a massive economy. China is a quote unquote strategic adversary of the U.S. government, but we have an extensive economic relationship with China. And so, and companies very much are involved in have operations in China, or have subsidiaries in China or partners in China. So that, there may be some room, depending on the nature of transactions, depending the mitigation steps that you take in order to protect, U.S. data. So there could be an opportunity there for authorization.
I mean, Ajay, I'm interested in that licensure kind of concept that you were describing a moment ago, because, I think one key question that we'll have here, because this law crosses over amongst kind of different subject matter domains, where is the responsibility for oversight with compliance going to sit within a corporate organization? We'll talk a little bit about that maybe on our next episode around compliance programs. But one thing that I think will be unusual for if this ends up sitting within the privacy group, for example, is the idea of licensure, right? There's not usually data licensures to allow for you to do certain types of things. Does that have any parallel in other areas of law, whether that's CFIUS or whether that's in sanctions law or other areas of export control that could give guidance about how we could expect to see a licensure framework play out?
Yeah, so I think, and you raise a really good point, which is, given the various types of issues involved in this rule, you're going to have various stakeholders in the company that are interested in this issue. And so, where does this sit? Who's responsible? How do you go about getting authorizations? All of that is going to be very important. And what you might see happen, and we see this in other areas, is, the function may sit in a particular group. So let's say an organization decides this needs to sit with privacy because the privacy people really understand the data flows. But they're going to need help, right? And they're going to need help because they don't necessarily know how to go get a license from a national security agency. But the people in the company that do that on a daily basis in the Global Trade Organization, they do know how to do that. So it may be that the function may sit in one place, but it pulls in. It pulls in other parts of the organization in order to engage in particular tasks. So I could see almost a council-like structure or a committee-like structure within a company that pulls in the relevant stakeholders, not only to kind of design, develop, and implement a compliance program, but also to obtain and seek licenses. So I don't think it has to be just one organization that does everything. I think they're going to, by necessity, they're going to have to reach out. And we've seen that in other places. And so, for instance, when we do work on export controls, or we do work on sanctions, we're constantly pulling other parts of the organization. And sanctions, finance, and the treasury functions are so important because the financial flows are important in sanctions-related authorizations, right? So you're pulling in those parts of the organization to really understand the financial flows and implement, compliance steps in different parts of the organization so you can comply with the license requirements. On the export control side, often, in a technology company, it's the software development and the engineering side you're pulling in because you have to understand the product, or you have to understand the transaction, and you have to understand the technology. So we, as trade people, often work with multiple parts of the company in order to, make this happen, in order to get it right. So that's going to be even more of a premium, I think, with this regime.
Yeah, and require that multi-stakeholder effort, right? At that way, to get this right. And the other group that I don't think we've mentioned yet, but is just as important, is going to be the cybersecurity function. And you mentioned a couple of the ways that organizations can be able to still get their deals done, including through licensures. The other way is going to be around, okay, we can still engage in these types of activities, but we effectively need to be putting in place the cybersecurity safeguards that will protect the data either in the hands of the recipient or through the transmission. And so in connection with this NPRM and the proposed rules that came through DOJ, there was a parallel set of standards that were proposed by CISA that would lay out a number of safeguards that CISA will require that organizations implement to allow for some of those prohibited transactions, the restricted transactions to continue. Now, the thing about that, right, is that they're providing a whole bunch of general things. Some of those things will be ones that you would expect. Some would be probably surprising, like more privacy-oriented safeguards. But in the end, the standard will be a significant one, because they will say that you need to do all of these efforts in order to prevent the third party or the country of concern from gaining access to this information. And that is a really high standard indeed, right? It's almost strict liability. And most organizations who are operating, on a commercial basis don't have the resources, expertise, or frankly, the capability technically to say that they will never allow access to individuals who are using state resources in Iran, or state resources in Russia, or state resources in China, or any ones where we're talking about using taxpayer or country level funds to be able to perpetuate cyber oriented activities. So I think it's going to require that group of stakeholders too to say, all right, we're going to allow for these transactions to continue because their business the transactions are fundamental to the business, but it's going to require bringing that group in place, saying, how is it that we safeguarded this data? And how is it that we can be assured that a country of concern can't gain access to it in the hands of the third party that we have contracted with?
Yeah. Yeah, I think that's right. And what makes this even more challenging is there's an additional layer of complexity on top of the countries of concern. It's also covered persons, and they've defined what covered persons are. The definition includes, for instance, foreign entities that are 50% or more owned by a country of concern, foreign entities that are organized or chartered under the laws of a country of concern, so companies from these countries of concern, foreign entities with the principal place of business in the country of concern, foreign entities that are 50% or more owned by a covered person. So in other words, these are OFAC concepts that they've taken. So these in the OFAC world, we have what's known as specially designated nationals, the list of bad guys, and they have what's known as shadow SDNs. SDNs that aren't listed, they're not on the list, but they're owned or controlled 50% or more by someone on the list. So when you do your diligence, you have to not only check the list and say, okay, is someone I'm dealing with when it comes to these covered data transactions, data brokerage transactions, are they on this list that DOJ is going to promulgate? But you also have to know the ownership structure of anyone you're doing business with in these types of transactions, because they might be owned or controlled by a person on a list or owned or controlled by an entity that's from a country of concern, right? So this is extending these OFAC concepts, importing them into this DOJ framework, which, again, this is the level of expertise you're going to need as an organization that the data on the data privacy side, you just may not have seen, right? But your OFAC people may have seen it. And so you're just going to have to work across these lines in order to get this right.
I think 100%. I mean, it's almost like it's a concept of like KYC or know your customer. And now it's a much broader version of that. And, another phrase that I've been using with clients and may use with other episodes is like, know your data. Because now we have to know what exactly the data is that we're going to be transmitting to everybody. And again, are all areas of knowledge and detail that may not really be the focus of many kind of relationships. But maybe, Ajay, I'm interested in your perspective on a key question that I'm sure many folks are saying, okay, but this are rules of the Biden administration. And importantly, we've had an election and the Biden administration will be exiting in about a month or so. We're recording this mid-December 2024. And so is this really just something that appeared on paper but will never actually become final? Interested in your perspective on, what does the changing administration mean for these rules, and will the notice of proposed rulemaking actually become a final set of rules?
Sure, great question, and we certainly understand from the Justice Department that they are working to issue final rules before January 20th inauguration, right? So January 20th would be the final day before inauguration. And so they are working around the clock, we understand, and spending their holidays working on this rule. So that's the expectation, is that the final version of the rules will be issued before the new administration takes office. Now, that doesn't mean that the rules will definitely be implemented. Certainly, the new administration could come in, and even if final rules were issued, they could hit pause on implementation of the rules and take a look at the rules, or even change the rules. So all of that is possible. Now, I will, for the folks who are hoping that will happen, I will caution you, say that there is not a lot of daylight between the current administration and the new administration when it comes to national security measures involving countries like China. right? I think we've seen, actually, regardless how fractious and polarized Washington, D.C. is, you've seen a great degree of agreement when it comes to, turning the screws on China when it comes to national security measures. So I would, even if, so in concept, I would think that an incoming Trump administration would generally agree with protecting U.S. data from access by countries of concern such as China. Now, they may have their own view on how this should be implemented. They may have their own view on which agency should be involved, and that remains to be seen. So I would say that if I had to handicap this, I would say this will be implemented in some form, but we'll have to wait and see.
And then Congress probably also has a role too with the Congressional Review Act, which, during the first Trump administration, Congress took action and got rid of things like net neutrality. But for probably the same points that you're raising here, Ajay, is that the political environment may not be one where you would expect Congress to try to overturn a regulation like this that's targeted at specific countries that where there's a lot of vocal critics of China and other based countries, and other based countries in Congress. And frankly, because it's a national security law as opposed to some other type of regulation, it also enjoys more bipartisan support.
Yeah, I think that's right. In fact, I think you saw in the last Congress, well, I should say this current Congress has been quite critical of the Biden administration on certain national security issues involving China. There was a House Select Committee that was really pushing the Biden administration to do more in various areas. And so it's a competition to see who's tougher on China rather than let's pull back on national security restrictions on China.
Yeah. Okay. Well, I totally agree with that. And I think that as a result, planning for these types of new cross-border data transfers is probably going to be well in the interest of organizations who have significant exposure to China and to other countries of concern, perhaps. Interested in any final kind of thoughts you have around how organizations can start to plan for what their new reality will look like as they seek to comply with these new requirements.
Yeah, and I think it's a little bit of what we discussed before, which is really treating this as a new national security program that's going to require an effort by the company to implement and to stand up a compliance function, around this set of rules. And I think that means, number one, identifying the stakeholders within the company and thinking broadly about that, as we've discussed, all the different stakeholders who can offer some expertise with regard to this issue, bringing them together, and then looking at the data flows, looking at the different types of data that are at issue in the rules, and does the company have those? Where, mapping out the data, where it's located, how does the data flow between, within the company, flowing into the company, within the company, and out of the company, right? Mapping all this out so you have a good understanding of your data flows, and then starting to think about, how do we implement policies, procedures, guidance documents, and so forth, in order to ensure that we are compliant. This is going to, I think this is going to require some effort. So I think it's important companies really take a close look at this rule.
Yeah, I think those are really good practice points. Well, Ajay, really enjoy every one of our experiences to work together and to learn about kind of how these new rules are going to impact both of our practices. But I also appreciate your willingness to share your expertise with our audience, and I'm sure we'll be probably having future episodes as these rules start to develop and take final shape.
Sounds great, and it's been fantastic being with you, Scott.
Terrific. Well, with that, I'm Scott Loughlin. This is the Data Chronicles, and those were your data points.